Today I'm going to be speaking of the discrimination of homosexuals and transgendered individuals in the workplace by William S. Center and Jamie Anderson's Law 2150 class at Appalachian State University. Where can you be fired for being gay? Simply put, there are 29 states in the United States today who do not have the Workplace Non-Discriminations Act, which means that any gay or transgender individual can be fired from that job for the purpose that they are gay or transgender. What does this really mean? 4% of people in the workplace are identified as gay, lesbian, or transgender. 21% of LGBT members have reported being discriminated against by their employer. 47% of transgender individuals have experienced severe discrimination in the workplace by employers. The average gay man makes 60 to 86 cents for every dollar a heterosexual man can make in the United States. Employees who learn that a particular employee is gay have been asked to keep their sexual orientation to themselves or to keep them out loud. What is really happening? Many employers in the U.S. ask on their application process if you are homosexual. Laws have been passed to prevent this kind of questioning, but really they hide it till later in the interview process and use wording that is so benign that they can get away with it. At this point, there are 0 federal laws are in place to prevent LGBT discrimination in the workplace. There are no state laws in 29 states today, and in 32 they do this based on gender identification. This causes a job opportunity decrease for all LGBT community members in the United States. What does this cause? Harassment in the workplace by other employees when they find out another employee is gay. Individuals are being fired from jobs they are more qualified to keep due to employer bias and employee issues. Transgendered individuals have been fired after retaining a job for years, but when another employee states that working with that person violates their beliefs, the company will in many cases fire that employee. A university professor was recently fired due to the fact that his students presented the fact that he was a transgendered male. Employment Non-Discrimination Act, a bipartisan proposal which is based off the Title VII discussion in class under the Civil Rights Act of 1964. This is being proposed now in the United States Congress and has been proposed every year but once since 1994. The bill, if passed, will finally make it illegal for any employer to fire, refuse to hire, harass, or refuse to promote any employee simply based on their sexual orientation or gender identity. Kronberg vs. Casper is a very good example of this. Josh Kronberg-Rasner was a male employee at Casper Foods in Casper, Minnesota. He is an openly gay worker who had never had a problem with another worker due to his sexual orientation. When a new supervisor was hired for the unknown hated gay man, the supervisor went through Kronberg's phone finding a new picture of his spouse. The next week, Kronberg was fired on the basis of poor work quality. However, the manager made comments to a female employee who later spoke to Kronberg of why he was fired, and they both agreed on the basis to sue. The outcome of this case is, when this case came to court, Kronberg's attorney brought forth a new avenue of an old case where a woman could not be fired due to their not following the gender stereotypes in the workplace, Price versus Waterhouse. They concluded it would be no different if a woman employee had a new picture of their spouse on their phone. The court ruled that the Casper Foods violated test by using the gender stereotype would have violated INDA if it had not installed in the White House. Kronberg was by request reinstated and the supervisor terminated for discomfort with several other employees. The Title VII of the Civil Rights Act of 1964 in its current state does not protect sexual orientation or gender identity. This leaves a large group of individuals without protection. Currently, INDA, which would correct this issue, is currently stalled. There is increased workplace discrimination for transgendered individuals and homosexual people in general, several cases where injury has occurred. Title VII has been rejected in these cases. DeSante versus Pacific Telephone and Telegraph Company in 1979, leading case of LGBT rights, the employee argued to be protected under Title VII and specifically towards male employees who were fired for being too effeminate. Elaine versus Eastern Airlines, 1984, where a male airline pilot transitioned to a female and was fired. The plaintiff in this case, of course, won for the first time by trying to put her in the female category of Title VII. But the Supreme Court stated by all accounts he is male as the day that he was born, and they could not use this defense under Title VII. A change came in the Supreme Court cases following Price versus Waterhouse. They announced that the Title VII would protect employees from stereotypical harassment from employees of the same sex, male versus male and female. Schwank versus Hartford, 2002, a transgender male in prison was raped and brutally beaten by a guard. The guard defended that transgender individuals were not protected under the Sex Discriminations Act, but the court ruled against them. They upheld case law stating that discriminating due to one failing to act like the assigned sex is no right for abuse and will be upheld under Title VII. The scholars think today, does INDA have a downside? The answer The simple answer is yes. Many scholars believe even though the bill lists new ways for discrimination to be stopped in this track, there is a loophole many at the beginning didn't catch. It's a loophole that allows any religious organization, churches and businesses, and more to discriminate against gay and homosexual individuals even more than before. What does this really mean? Scholars at the University of Georgia have taken a pro-trans American stance against INDA. Truly, it's a bill that is hiding a dark side in it. When it was brought onto the Congress floor, it was portrayed for being a new innovative way to protect the LGBT community. But really, it would allow businesses and individuals to ban gay people from even entering into a business if they so wish. They have made it clear that they see this as being very close to the Jim Crow law in the South. This is a religious tolerance issue many Republicans have argued. Many do not want their businesses to serve homosexuals beside their God-fearing children. The right to obtain employment free from discrimination has been a staple in American justice system since the passage of the 14th Amendment in 1986. Gay men, lesbians, and bisexuals do not have a federal case of action to commit workplace discrimination based on sexual orientation, shared in the University of Law in Kentucky. How do we distinguish gay individuals, many scholars have asked? By the way they walk, talk, or act? No, this is no better than setting everyone in a stereotype. Neither are we asking all gay individuals to hide, but don't want to live in a society where a group can be blocked from a grocery store or a bakery due to the fact that they may or may not love another man or woman. The case that they really brought about this gender stereotype issue has been used in many workplace discrimination cases is always Price versus Waterhouse. The case, based on the ideals that Price was fired due to the fact that she acted more aggressive during work and didn't fit the woman's gender role in the workplace, being taunted for acting more like a man. INDA is just the beginning in the 1990s. It was brought up to be affixed to the Title VII portion of the Civil Rights Act of 1964, but now we have a more diverse group such as transgendered, cisgendered, and a slightly lesser-known cross-gender community who also has its own plight in the workplace. Many universities debate INDA, including Stanford Law and Harvard, in an attempt to determine if the passage will cause relief or more harm. Why is INDA really stalled? We have two sides everyone knows in politics. The INDA bill is stuck in the Republican side of Congress. They state that INDA will violate the religious freedom of business owners and employees if they do not want to service the LGBT community. What the INDA bill already states is that if a business is already exempt from the bill, that they can still hold their religious beliefs. They just cannot punish any person or cause undue harm to the fact solely that they are a part of the LGBT community. The conclusion on this case is, the plight for LGBT rights in the workplace has been one that has gone on for decades. Title VII did not include them in 1964, but has come to make new interpretations in cases being brought to attention. INDA is a double-edged sword for which one will get LGBT members stronger and unbreaking rights to the workplace against discrimination, but at the same time may face other discrimination with the religious reform portion. Many have worked hard to be able to work and live their lives normally like anyone else. There is a light at the end of the tunnel. How far that tunnel is will be determined by the future decisions. Our world is constantly changing. In the next few years, we may see a change.